when a law firm is considering to purchase another firm, they're doing all types of due diligence in terms of finding out, all right, what is that final retention policy of the selling attorney? How do they handle original records? So just to get a little bit into the weeds, when we're negotiating law firm sales, we're typically identifying, when it comes to files, we're identifying the open matters. That's a no-brainer, right? The open matters come over to the buying firm. We're typically also saying, well, the recently closed matters, right? These are matters, let's say within a 7-year period, can be less, depending on the practice type. Perhaps those files are coming over to a buying firm as well. When it comes to closed files over a certain number of years, what we find often is that buyers really don't want to take on, particularly the paper files of senior attorneys that go back, let's say, more than 7 years, except for, as Elizabeth points out, original records, right? I mean, if you're an estate planning firm and you've got original wills and original other types of documents that are valuable to the future of the firm, then for sure those types of original documents can stay. But if, let's say, a real estate firm, and that firm happens, that is the selling firm, happens to has the records from the sales that they were the lawyers on from 10 plus years ago, in our experience, often the buyers will say, please, you, Mr. or Ms. Seller, you need to either return those files to clients, destroy the files, or proverbially speaking, they wind up in the seller's basement. And by the way, that's not necessarily proverbially. Sometimes that actually does happen.